Sir, good morning, sir. It is audible, sir.
Morning, sir. Yes, it is audible.
Thank you, sir. Just we are giving one introduction, sir. Then we will start your session, sir.
Okay.
Thank you. Good morning. This is Dr. Senthil Kumar from Panimalar Engineering College. I welcome you all. They started with the introduction, and Dr. Sandana Lakshmi, Assistant Professor of our department, is going to give the introduction about our chief guest, and then we will start the session with today. Thank you.
So, shall I start?
Start.
Good morning and a warm greetings to everyone. With the great blessings and guidance of our Secretary and Correspondent Dr. P. Chinnadure, MA PhD, our directors Tirumati C. Vijay Rajeshwari, Thiru C. Shakti Kumar, and Saranya Sri Shakti Kumar, and with the prominent motivation of our principal Dr. K. Mani and our head of the department Dr. L. Jabishila, I, S.T. Santanalakshmi, Associate Professor from Computer Science and Engineering Department, feel honored to welcome Mr. Himanshu Chandrakar, Examiner of Patents and Design, Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur, to this online workshop on intellectual property rights, IPR, and patents and design filing. Mr. Himanshu Chandrakar is working for more than 6 years in Indian Patent Office, Ministry of Commerce and Industry, Government of India, and presently working as Examiner of Patents and Design at RGNIIPM, Nagpur. He is examining and dealing with national and international patent applications filed at various patent offices across India. He has done Bachelor of Engineering in Mechanical Engineering and has delivered many lectures in IPR in various parts of the country. On behalf of the management and on my own behalf, I welcome all the participants to this online workshop on intellectual property rights, IPR, and patents and design filing. And once again, I welcome Mr. Himanshu Chandrakar to deliver his valuable keynote. Thank you all. Sir, over to you. Thank you.
Thank you, ma'am.
Thank you, sir. Thank you.
So I have shared my screen. Am I properly audible?
Yes, sir. Yes, sir. Screen also
Yes.
visible. It is good, sir.
Yes, yes. So shall we move ahead?
Yes, sir. Yes, sir.
Yes. Yes. Okay. So my name is Himanshu Chandrakar. I'm Examiner of Patents and Design at RGNIIPM Nagpur, and we are here for workshop on intellectual property rights. Okay. So this particular session is under the mission of this National Intellectual Property Awareness Mission. So this is a mission which has been launched by government to create awareness among students, faculties, and innovators all over India. So before moving to the IPRs, brief about our office is that our office under Ministry of Commerce and Industry. Under this ministry, there is Department for Promotion of Industry Internal Trade. Under this department, there is an Office of Controller General of Patents, Design and Trademarks. So under this office, there are different offices you can see here. So these different offices are for different kinds of intellectual properties. Like for patent, there is patent office. For trademark, there is trademark registry. For design, there is design office. So based on intellectual property rights, there are different offices. Okay. So for patent office, there are 4 branches. Trademark 5 branches in 4 metro cities and Ahmedabad. And designing only Kolkata office is there. GI Chennai, copyright Delhi office, and semiconductor IC layout and design registry in Delhi, and training academy is at Nagpur. So here in Nagpur, we provide training for different types of intellectual property rights for patents, trademarks, designs. Okay. Okay. So this intellectual property. So what is intellectual property? Intellectual property means any creative ideas and expression of the human mind, they have some commercial value when you give shape to those ideas. Okay, so any creative ideas, when you give shape to those ideas, they have some value in the market. Such type of ideas will be called as intellectual property. Why it is called intellectual? Because it is coming from your mind. Okay, this intellectual property has certain features. Okay, so these are intangible, you cannot touch your ideas. Okay, it is having some commercial value and it is an asset like any other form of property. Suppose you are having a land or house. Similarly, intellectual property also an asset. So you will get all kind of right which you are getting with your land or house. So in intellectual property, you can sell your intellectual property, you can license your intellectual property. Licensing means it is similar to giving rent for your property. Okay. When you rent your property, you earn some monetary benefit out of that rent. Similarly, in that licensing also for your intellectual property, when you give license, you earn some royalty. Okay. Exclusive rights. This intellectual property, when it is registered, the rights will be exclusive to the person who has registered it. Okay, the applicant. The applicant will get all the rights for his intellectual property after registration. Territorial rights means the rights will be applicable within a boundary of particular country where you have registered it. Okay, suppose you have registered your intellectual property in India, then you can use your intellectual property. You can you can exercise your rights for your intellectual property within the boundary of India, but you cannot claim your rights in other countries like China or USA. For that, you have to go for registration. Okay. Next is limited period. For different types of intellectual property rights, there are different term of protection has been given. Okay. So for patent, it is 20 years. For design, 10 years has been given. So there are different types of intellectual property, and different terms have been given. The rights which you are getting for your intellectual property after registration will not be long lasting. Okay, it will be for a limited period of time. So we need a brain to think of an idea. We need resources to give shape to those ideas, and we need manpower. Okay, the person who is giving shape will be called as labor. Okay, so these three things are when combined, we get a property which is called intellectual property. This intellectual property, when it is registered under the government of India or any other country's government, then the person who is registering it, the applicant, he protects his right, he excludes others. Okay, by doing so, he utilize commercial earn. Okay, he can utilize commercial earn from his intellectual property. So he can use for own purpose, he can license his rights, he can assign his rights, and he can earn by franchisee and merchandise also. Okay, so this way they can commercialize their intellectual property rights. Intellectual property right has different forms, patents, design, trademarks, based on the field of your idea. Based on the field of your idea, there are different forms. Suppose if you are thinking of some poem, some story, so you will go for registration under copyrights. If you are having some invention, then you will go for patent registration. Okay. If you are developing some design for any of the article, then you will go for design registration. Okay. So based on the field of your idea, different forms have been decided, and we will discuss these different types of intellectual property rights one by one. So first I'm dealing with the copyrights. What are copyrights? Copyright is a legal term describing rights given to creators for their literary, films, dramatic, musical, artistic, and sound recording works. So if you are having any of the works based on your ideas in any of these fields, then you can go for registration under copyright. Okay, so literary work, like if you are having some book, some poems or something, some story, then you can write it on some paper, you can publish it, and you can register under copyright. Films, if you have produced some film, you can go for registration. Dramatic means some stage performance like acting, singing, dancing performance. Musical means if you have composed some music, you can register it under copyright. Artistic means painting, sculptures, drawings. Sound recording, recording some song yours or something, it can be registered under copyright. Okay. Who will be the owner of the copyright? So the owner will be the applicant in general. Okay. Or the person who is causing that work to be done. he will be the owner. So suppose for literary and dramatic work, the author, he will be the owner after registration of his literary and dramatic works. Okay. Music work, the music composer, the person who is creating that music, the person who is making that music, he will be the owner. Artistic work, the person who is creating that art. Okay, the person who is painting, the person who is making some sculpture, he will be the owner of the copyright after registration. Photograph, the person who is taking the photograph. Next is cinematographic films and sound recording. This is important. The producer, he will be the owner of the copyright after registration under copyright. Producer means the person who is investing money on that film or sound recordings. Here, no director, no actor. Okay. If they are not investing money on that film, they will not be the owner. The producer, the person who is investing money, only he will be the owner for that film or sound recordings. Okay, this is applicable for any kind of intellectual property rights. Okay, means the person who is investing money, the organization who is investing money, they will be the owner. Okay, suppose you are an independent photographer and you are doing photography work, you are editing your picture and you are selling that picture, you are after registration under copyright, you are selling that picture in the market. So you will be the owner of the copyright because you have done this photography work for your own purpose and you are independent. But if you are a photographer under some organization, the organization is paying for your photography work. In that case, the owner will be your organization who is paying for your work. Okay, because they are paying you for your work and that's why they are the owner. Okay. What comes in the literary work? So books, newspaper, question paper, catalogs, dictionaries, computer software and computer programs. So if you have developed new kind of software or program, then it can be protected under literary work of copyright. So in copyright itself, there are 4 categories. Okay, 4 category under which you can protect uh, your work under copyright. Okay, so first is literary work. So for literary work, when you protect your work under literary work, then you will get you will get a term of life of the author plus 60 years. So this will be your term, this will be your protection period for your copyrighted work. Okay, so suppose if you have written lyrics of a particular song, if you protect it under copyright, then for this much period, your rights will be protected. Okay, means until unless the author is alive, plus 60 years means after the death of the author, this copyrighted work will be protected. Okay. Next is broadcaster's right. Broadcaster's right means suppose you watch IPL matches on some channel. Okay, why you are watching that IPL matches on that channel? Because they have taken broadcasters right for all the matches of the IPL. Okay, so no other channels like suppose it is being broadcasted on Star Plus, Star Channel or Star Sports. Okay, so other channels like GTV or Sony TV, they don't have any rights over that IPL broadcast. Okay, for how many years? 25 years. Okay, so for 25 years you can protect your rights under broadcasters right, which is another category of copyright. This is second category. Okay, and what is the procedure to apply for copyright registration? So here is the procedure. So here you have to file this form 14. Along with this form 14, you have to submit your work, whatever you have created. Along with that, you have to pay certain fees. Okay, so these are the fees for a particular category. You can see these are the fees for different categories. And as I said, there are 4 categories under copyright. So for each category, there is different term. Okay, so for literary, dramatic, artistic, and musical works, the term is life of the author plus 60 years. Okay, these are all copyright. Okay, next is cinematography, films, and sound recordings, 60 years. Broadcasters right, 25 years. Performers right, 50 years. So these are the terms which have been given for each category of copyright. Next is industrial design. What is design? So design means any feature of shape, configuration, pattern, or ornament or composition of lines or colors applied to any articles in 2D or 3D form. Okay, by some industrial process or means, whether in 2D form or 3D form. So changing outer appearance, outer shape of a particular article or product will be termed as design. Okay, so when you apply for design registration, it should be a unique design, the design which is not available in the market. So then it can be protected under design. Okay, when it is registered, the term you will get will be 10 years, which can be extended for another 5 years. So total 15 years you can use your work, you can protect your rights for this term, that is 15 years. Okay, for design. Suppose this is a bottle, it is a very simple bottle. If you change this outer appearance of the bottle from this to this, then you can apply for design registration, provided that design is unique. Okay, similarly, if you are a fashion designer, if you change the outer appearance of the dress, if you design any new kind of dress, then you can apply for registration under design. So if you change the outer appearance of the mask, watch, bicycle, then you can apply. Even you can change the outer appearance of this bicycle seat also. Okay. So how to apply for design? So you can apply your application in online mode or offline mode. Online mode, there is a link on our website, comprehensive e-filing. You have to refer, and you can apply your application online. And for offline, you can apply your design application to your nearest patent office like IPR Delhi, Mumbai, Chennai, and Kolkata. As per your distance, you can apply your application. Okay. So after that, your application will be processed in Kolkata office. Okay. Processing means it will be checked for uniqueness. Okay. But how to apply for design? Okay. So for design, you have to apply this form 1. In this form 1, you have to provide basic details of applicant. Okay. Along with that, you have to pay certain fees. What are the fees? So it is 1,000 rupees for some individual, small entity or startup. If you fall other than this category, then you have to pay 4,000 rupees. 4,000 rupees will be the fees if you are other than this category. Okay. And along with that, you have to provide these 2 sets of representation for various views of the article. Okay. What will be this representation sheet? Suppose you have designed a teapot. Okay. So if you design this teapot, then you have to submit in the office different views of this teapot, from front, from side, from back, from top, each and every possible view, so that one can understand what you have designed. Okay. So you have to submit very clear pictures of your design. Along with that, you have to write some disclaimers. Okay. You can see here, and that you have to sign. So this will be your representation sheet, which you have to submit with your application for design. Okay. Suppose you have designed some article which are sold together in the market, or they share similar kind of design. If I talk about this jewelry set, in this jewelry set, you can see there are more than one article. That is, one earring is there, a necklace is there. Okay. So such type of things can be applied in a single application by paying only one-time fees. Okay, only one fees you have to pay for whole set. You don't have to apply for apply separate application for this earring or necklace. Single application, single fees, you can apply for whole set. Similarly, for sofa set, teapot set, pair of shoes, you can apply. Okay. Next is, once your application, you have applied your application, then so your application will be processed in office. Okay. So how it will be processed? So it will be checked for uniqueness. So whatever you have designed will be checked whether it is unique or not. Your name, your forms, your fees, everything will be checked. If there is any objection in your application, then the same will be raised in the form of first examination report. This first examination report will contain some objection which you have to comply with within 6 months. If your replies are satisfactory, your application will be registered, your design will be registered, and you can protect your rights for 10 years from the date of filing, not from the date of registration. From the date of filing, you will get 10 years. Okay. Generally, the process of registration for copyright takes maximum 6 months, generally. Okay. And this 10 years you will get. After that, you can extend also for another 5 years. Once your design is registered, you will be issued a certificate from Government of India, that is Design Office. So this certificate will look like this. Your name and address will be mentioned here. HO, head of office, or will be signing here. Okay, your design number will be mentioned. So this will be a certificate, some documentary evidence that your design has been protected. Once your design is protected, it will be published in this patent office journal. Okay, so under design section, you will find your design, whatever is registered. Okay, suppose you have designed a chair. Suppose, okay, I am telling you how to commercialize your intellectual property right. Suppose you have designed a chair. Okay, so this is your chair design. Okay, suppose this is your chair design and you have applied for registration under design. It was registered. Once it is registered, it will be published on journal. So the images, the photographs which you have provided along with your application will be shown in this publication. Suppose this was the design, this chair will be published here. Okay, along with that your name and address will be mentioned. Okay, so you can use this design, registered design, for your own purpose. Your own purpose means you can manufacture the same design chair in your manufacturing industry. You can sell it in the market and you will gain all the profits which you are getting for that design, and it will be along with you. It will be along with you. But you can, if you are willing to license it, if you are willing to assign it, you assign your rights, then you can also go for licensing or assignment. In that case, suppose you are not manufacturing a chair and some other manufacturing company like Nilkamal, they generally manufacture chairs. Okay, so they come to you, they ask for license. Sir, this design looks attractive. Please give us a license. We will pay some royalty in return to this license. Okay, royalty means so they will manufacture the same design chair what you have registered. They will manufacture it in the market. They will sell it in the market. They will earn some profit. After that, when they are earning some profit, they will pay some royalty, means some percentage of their profit as a royalty. Okay, suppose they are earning 1,000 rupees for each chair, so they will pay you around 100 rupees or 200 rupees as a royalty for your license. If you are selling your rights, then they will pay you some lump sum amount, and after that all the rights will be applicable with them. Okay, you will not be having any rights over that chair. They can do whatever they want after you have sold your rights. Okay, so this way you can earn from your intellectual property. Next form of intellectual property is trademarks. Trademarks is a sign capable of distinguishing the goods and services of one enterprise from those of another enterprise. So any sign which is capable enough to tell about its origin, to tell about its reputation, to tell about company's name, such type of sign or symbol can be called as trademark when it is registered. Okay, suppose this is Adidas. Adidas, when you see this logo, when you purchase some product, if you see this logo on that product, then immediately you can tell that this product belongs to Adidas company. It is having some reputation of that company. It is having quality because of its name. Okay, so each and every details are with that symbol only. Okay, to protect this reputation, to protect this name, this quality, company register this logo or symbol for trademarks. If they don't register this logo, then anybody can manufacture a duplicate product and they can use this logo, which will harm the name to the company. Okay, so to protect their name, to protect their fame, their reputation, they register it under trademarks. Okay, once it is registered, anybody is using this logo, they have to take permission from the trademark owner, that is Adidas owner. Okay, similarly this at Nike company, you can see Puma. Okay, so these are all registered trademark. What can be the subject matter if you are applying for trademark registration? So you can apply for name, tagline, certification marks, you can apply sound marks, combination of colors, smell, moving marks can be applied for registration under trademarks. If you have applied your application, but if your application is pending under office, then you can use this TM under your logo. If it is registered, then only you can use this registered symbol, registered tag under your logo. Suppose this is the FedEx. FedEx, under FedEx you can see small r is written. This small r so that this FedEx is a registered trademark. If anybody is willing to use this logo, this symbol, then they have to take permission from the FedEx owner. Okay. If it is TM here, means this FedEx is under processing for trademark registration. Okay. Next form of intellectual property is semiconductor integrated circuits, layout and design. Okay. So you might be using some electronic items. When you open that electronic items, your laptop, your mobile, you may find some integrated circuits, semiconductor chip. Okay. So inside that semiconductor chips, there are different layout, positioning of transistors, insulating materials, okay, and some circuitry elements, their layout, their connections, their arrangements, which are very minute. Okay, so such type of arrangement can be protected under layout of semiconductor integrated circuits. Okay, so for that you have to apply your application that layout under this SICLD registry office Delhi. Okay, and you can apply your application. Once your design is registered, your layout is registered, you can use your rights for that layout for 10 years from the date of filing or first commercial exploitation, whichever is earlier. So this is next form of intellectual property right. Another is geographical indication. Okay, so geographical indication is another form of intellectual property rights. As the name suggests, indication of a particular geography. So geographical indication is an indication that identifies a product that have a specific geographical origin and possess qualities or a reputation that are due to that place of origin. Suppose here, if I take example of Darjeeling tea, Darjeeling tea. Okay, so the tea which has originated from Darjeeling area, the tea which was cultivated in Darjeeling area because of its weather condition in Darjeeling, because of the skills the farmers are having in Darjeeling area, this tea has got unique quality, unique taste. And because of its quality and taste, because of its place of origin, it is famous in the market. Okay, so such type of reputation and quality can be protected under geographical indication. Means a product with its geographical origin can be protected under geographical indication. Okay, so you can see there are different GI, their logos. You can see Darjeeling tea, it is logo of Darjeeling tea. It is Makrana marbles logo. Okay, Bastar Dokra art logo. Okay, Nilgiri tea you can see. So there are more than 400 registered GI tags in India. The first registered GI was Darjeeling tea. It was Darjeeling tea got first GI tag in India. And Makrana marble, you know, this Makrana from Rajasthan, marble which is coming from Makrana area of Rajasthan. It is famous. It has got GI tag. Ratlami se from Madhya Pradesh, Kanchipuram silk from Tamil Nadu, Bidri ware from Karnataka, Worli painting from Maharashtra. Okay, so there are more than 400 registered GI tag. Kashmir Kesar, Sahi Lichi of Bihar, Magahi Pan. Okay, so these are all registered GI. Next is patents. Next form of intellectual property is patents. Before moving to the patents, I have provided you a link. Okay, just a minute. I have provided a link. The link I will be pasting in that feedback link. Sorry, chat box. I will paste that link on the chat box after this session, and you can copy that feedback link. Also, you can ask your coordinator. Okay, for that feedback link. So the participant who are joining this session, they have to fill that feedback link. They have to fill your details. Along with that feedback link, you may find a IPR information booklet. When you scroll down, you will find IPR information booklet. So there is an attachment where you can see the summary of this session. Okay, whatever I am presenting you, you can see the summary of that session in that feedback, in that IPR information booklet. And also how to file different types of intellectual property rights. You can gain knowledge about that filing. Okay. Also the fees have been mentioned in that IPR information booklet. So please download that. It will be useful for you. Maybe not today, but it will be in the future. You will find it useful. Okay. Next is patents. Patents is, before moving to the patents, what is invention and what is discovery? So discovery means finding a new thing or property which was existing in the nature. So anything which was existing in the nature, nobody was aware of it, somebody has found it. Such type of finding will be called as discovery. Okay. Suppose gravity. Gravity was a phenomena which was existing in the nature. Nobody was aware of it until and unless Isaac Newton found that phenomena. Okay. So that's why gravity is called discovery, because it was existing in the nature. Invention, on the other hand, will be any new creation which was not existing in the nature. Okay, so this will be a general definition for invention. Means the thing which was not existing in the nature, if somebody has created, if somebody has created using their mind, then it will be called as invention. But when you apply for patent, okay, so your invention will be judged under certain parameters. Okay, what are those parameters? So novelty, inventive step, and industrial applicability. So when you apply for registration of your invention under patents, then it will be checked under these parameters. So whatever you have created, which you are claiming that it is an invention, whatever you have created will be checked under novelty. Novelty means whatever you have created, it should be either a new product or process which was not existing in the nature. Okay, so for checking this novelty, we will check for all the documents which is available in the nature. Okay, next is inventive step. So whatever you have created will be checked for its obviousness. Whatever you have created, it should not be obvious to the person skilled in the art. Person skilled in the art means person who are dealing in the same field. Suppose if you invent a modified bicycle, then the person who are dealing with the bicycles, the person who are selling bicycles, manufacturing the bicycles, using the bicycles, they all will be considered as a person skilled in the art. So the whatever modification you have done, it should not be obvious to them. That will be called as inventive step. Next is inventive industrial application. So when you apply your patent application, you have to submit some document. You have to describe your invention in such a way that if a third person is reading your invention, that document, then they should be able to manufacture it in the industry by just reading that document. Okay, by going through that document, they are able to understand how to manufacture it in the industry. If it is described in such a way, then it will be called as having industrial applicability. Okay, so these three criteria will be checked while applying for while checking for your invention. Okay, if all these three criteria were followed, then it will be called as invention. Suppose if I had example here, light bulb. Light bulb was a new product when it was invented for the first time. It was a new product which was not existing in the nature, so it was consisting novelty. Second is it will be checked for obviousness. So when it was invented, it was not obvious to the person who are dealing with the light source field, in the field of light source. Okay, so this light bulb was not obvious to them, so it was involving inventive step. It was described, it was written in some patent specification in such a way that it was manufactured in the industry. So it was involving industrial applicability also. So that's why it is called invention. Now, Thomas Alva Edison applied for registration of this invention, registration of his invention, that is light bulb. So once it was registered under patent, then we call it as light bulb was invented by Thomas Alva Edison because he patented that invention. Okay, so that's why we are calling it was invented by Thomas Alva Edison. Similarly, telephone was patented by Graham Bell, so we call it as it was invented by Graham Bell. Okay, so what is patent? Patent is a grant by sovereign or state to a person giving exclusive rights for to stop others from making, using, exercising, vending, and importing an invention for a limited period of time in exchange for disclosing it in a patent specification such that anyone having average skill in art can reproduce the invention in the industry. So patent is a grant for a limited period of time, that is 20 years. 20 years from the date of filing, not from the registration. It will be from the date of filing, 20 years. Okay. So what rights you get for your patent? You get rights to stop others, okay, from making, using, exercising, vending, and importing. Suppose you have developed medicine for treating corona medicine you have developed, you have created that medicine. You apply for registration under patent in India. As I said earlier, that any form of intellectual property rights are territorial. There are some exceptions for that territorial rights. So patent is a territorial right. Okay. So suppose you have applied for registration under patent in India for this medicine. This medicine was given patent. It was granted in India. but you're not applied for patent in China or America. USA, you are not applied for patent. So since it was granted patent in India, then in India you can stop others from making this medicine, what you have invented, using this medicine, selling this medicine, or importing the same medicine what you have invented. Okay, you can stop others, but you cannot claim these rights. You can stop others inside the boundary of India, but you cannot claim these rights in China or America because you did not apply for registration under patent in that countries. Okay, so the rights will be applicable within a boundary of country. Just a minute. Hello? Four. 4388 Next is how we will judge novelty, how we will check whether a particular invention is not existing in the nature. Okay, so for novelty, the criteria is it should not be existing in the nature. So we will check for published document in India or elsewhere. India and elsewhere means nature means everywhere we have to check. Next is we will check for public knowledge. If same invention was in public knowledge, then it cannot be called as having novelty. Okay, if the same invention was already claimed by someone else, so the person who claimed first, he will be getting the patent. He will be getting rights for that particular invention. Okay. So as soon as you get an idea, you should go for registration under patent. Next is inventive step. How we will judge inventive step? So we will check for the modification, the technical advancement what you have done. It should not be obvious to a person skilled in the art. I already have discussed it. Okay. So this will be inventive step. The first application which was applied for patent registration in India was an efficient pankha pulling machine. An efficient pankha pulling machine, it was applied by George Alfred Deepening on March 1856. You can see different scientists and their inventions here. Thomas Alva Edison, he has invented phonograph. He has invented phonograph. Alexander Graham Bell telephone. Wright brothers aeroplane. Louis Pasteur rabies vaccination. Alexander Fleming penicillin. Okay. These are also registered patents. Nanocar, hepatitis vaccine. So your invention can be very simple one. Okay. So you can see this baby shower cap. It has got patent. Okay, which is very simple invention. So you know this person, Michael Jackson, he has also applied for his shoes for patent registration. He got patent for his shoes. Okay. If you are willing to, if you're curious enough to see what was the invention, then you can just note this application number 5255 number 5255452. Just search this number in Google Patents. Okay, and you will know the details of this invention. In India, you can apply your application in Hindi or English. Two languages government is allowing. Okay. So for patent, what we need? We need an invention. For that, for invention, we need an idea. That idea we have to check. Why we are checking for the idea? Because we are looking for the similar application which has been filed for the same idea. If the same idea was already patented, then we will not get patent. For that, we are looking for the idea. We are searching for this idea. So where we can search for this idea? We can search in patent search engines and non-patent search engines. Patent search engines means if you search your documents in these search engines, then it will show all the documents which has been filed for patent for the same idea. Okay. So you can search in Indian Patent Office website, WIPO, EPO, USPTO website, Google Patents. So these are some websites where you can search. And link for these websites, for this website you can find on the IPR Information Booklet, where in that feedback link where I have provided IPR Information Booklet. In that IPR Information Booklet, you can find the link for this search engines. Okay. Next is non-patent search engines. So you have to search for the ideas in different non-patent search engines like Google Scholars, research papers, journals, YouTube, Yahoo. Everywhere you have to check for your idea, all the websites. If that idea is nowhere present, then you can ascertain novelty for your invention, inventive step, industrial applicability, non-patentability under section 3. You have to check it. It is mandatory. So there are certain things which are not patentable under section 3 of the Indian Patents Act. At the starting of the session, I said about computer programs and computer software. these are not patentable. Only software, if you are coming with only software, these are not patentable under section 3. Okay, so you can get copyright for that, but you cannot get patent for the same software and program. Okay, so you have to check for these things. You have to check section 3. After that, your application will be drafted and it will be filed. How to draft? You can see the granted applications. Okay, in granted application, you may find the way how to draft your application. Okay, after drafting, you have to file your application. How to file? So there are different forms which you have to file. That is form 1, form 2, form 3, form 5, and form 18. All these forms are mandatory. So in form 1, you have to provide basic details of applicant. Applicant means the person, after registration of the patent, the applicant will be getting all the rights. Okay, so you have to choose it wisely. Okay. Form 2, you have to attach your patent specification in this form 2. In this form 2, in the patent specification, you have to describe your invention under certain heads like titles, background of the invention, claims, abstract. In claims, you have to write it very carefully. It is the claims only for which you are getting rights for 20 years from the date of filing. Form 3, if you have filed the same invention in other countries also, then you have to give the foreign filing details under Form 3. Form 5, who are the inventors for your invention, you have to provide in Form 5. Form 18 is very important, request for examination. You have to submit this Form 18 within 48 months from the filing date, earliest priority date. Okay, 48 months, that is 4 years. So if you submit this Form 18, then only your application will go for processing and ultimately you will get decision for your application. If you don't file this Form 18 within 48 months, then your application will be expired. Okay, it will be beneficial for you if you file this Form 18 as soon as you file Form 1. As soon as you file your application, please file your 18 immediately. Okay, because based on the Form 18 date, your application will be processed. Generally, it takes around 2 to 3 years in today's scenario for your application to be processed. Sometimes it takes more than 3 years also. Okay, because we are having long pendency, but we are reducing this time period day by day. Okay. What are the fees for filing application? If you are filing your application online, then these are the fees. For Form 1, 1600 rupees. For Form 2, there is no fees up to 30 pages and 10 claims. More than that, you have to pay extra charges for claims and pages. Form 3, no fees. Form 5, no fees. Form 18, 4000 rupees you have to pay. Total 5600 rupees only you have to pay if you are a natural person, startup, small entity, or education institute. Okay, natural person means single person or group of person. Suppose you are 5 or 6 friends, then you are doing some research, then you can apply your application. All of you can be the applicant and you can apply your application only for 5600 rupees total. Okay, if you're other than this category, startup, small entity, other than this category, if you're a big company, then you have to pay 8000 rupees for Form 1, 20,000 rupees for Form 18, total 28,000 rupees. For other fees, you can refer this first schedule of patents rule 2003. Now, where we can file our application? We can file our application online or offline. Online means there is some website. In our website, there is some link. You have to go through that link, and you can apply your application. But you will need digital signature of class 2 and class 3. Nowadays, we are also accepting e-sign. Okay, you can apply your application, and if you are applying your application in offline mode, then you have to apply your application as per your jurisdiction to your nearest patent office in some hard copies. Okay, so like for south part of India, it is Chennai office. For northeast, West Bengal, Odisha, it is Kolkata office. For north of India, like Rajasthan, Uttar Pradesh, and other north states, it will be Delhi office. From Madhya Pradesh, Chhattisgarh, Goa, Gujarat, these states, they can file at Mumbai patent office. Okay. Also, you can expedite the examination. As I said, it takes around 2 to 3 years for your application to be processed to get decision for your application. But you can expedite the examination process by filing Form 18A. There is extra fees for Form 18A, but you have to fall under certain categories. Then only you can file this expedited examination. So if you are a startup, small entity, female applicant, or other categories, then you can file your application under expedited examination. Within 1 year, you can get decision for your application. Okay, how your application is processed? So your application will be processed in India in ordinary mode. Suppose you first disclose your application in India, then it will be called as ordinary application. In India, you can file provisional or complete. Provisional means you can file for your idea. You have to execute that idea within 12 months. Execute that idea and come up with complete specification. Provisional means only for idea. You will just describe your idea, what you are going to invent. You have to execute that idea and you have to come up with complete within 12 months from the provisional date. If your invention is already complete, then you will file directly complete specification. So the first date on which you are filing your application, either it is provisional or complete, will be called as priority date. Priority date means first date of disclosure of your application will be priority date. From this priority date, after and they will issue some report. In this report, there will be certain objection. If your application is having some objection, then they will raise in this first examination report. So they will check for novelty, inventive step, and your forms, your fees, they will check. If there is any discrepancy, there is any objection, they will raise in this first examination report. You have to comply with those objections within 6 months. If your replies are satisfactory, you have complied with all the objections, then your application will be granted. If still there are some objection pending, then they will again raise a hearing. They will ask for hearing. They will offer you hearing. In hearing, you have to stabilize your invention. You have to comply with the objection. If your hearing submissions are satisfactory, your application will be granted. Otherwise, it will be rejected. Okay. So this way your application will be processed in India. In other countries, you can go by PCT mode or conventional mode. If you're going by PCT mode, first you will file PCT application, then you will enter that foreign country within 31 months from the priority date, Indian priority date, you will enter that country, you will file your complete same application which you have filed your application in India, you will file complete and in the same manner it will be processed in that country. If you are going by conventional mode, then you can directly enter that country within 12 months from the priority date. You will file complete and same manner it will be processed. These are different timelines. You may take screenshot for different formalities. Opposition is very important. Suppose your application was wrongfully acquired from you. You were doing some research, but it was acquired by someone else. It was filed for patent without your knowledge. In that case, you can file opposition. Before grant, if you are filing, it will be called as pre-grant opposition. After grant, within 1 year, if you are filing, it will be post-grant opposition. For that opposition, you have to submit some evidences for your claims. If your claims are stabilized, then it will be that application which was stolen from you, which was acquired from you, will be rejected. Okay. What is purpose of patent? Why we are applying for registration for patent? So first criteria is we want to give a name to that invention. Second is we want to earn some money. We want to earn some commercial benefit out of our invention. Some are doing patent for academic purpose only. Okay. So how to commercialize? Suppose you applied for this medicine, corona medicine, in January 2020, you applied for registration under patent. Okay. So in that year, it was in huge demand. That medicine was in huge demand. So once it was applied for patent, it takes around 18 months for your application to be published. Okay, for your invention to be published. But if you file Form 9, within 1 year, within 1 month, your application will be published. So suppose you applied your application on January 2020, it was published on Feb 2020. In Feb 2020, there was huge demand in India. So the manufacturers and the sellers, when they see this publication, they will immediately manufacture it because there was huge demand. They will manufacture it in the market. They will sell it in the market, but they will not take your permission because patent is not granted. So you don't have any rights. Okay. So they will sell in the market. They will earn some profit out of your invention. When patent is granted, suppose it was granted in January 2022, it was granted after 2 years. So when patent is granted, now you have got all the rights from the date of filing, that is January 2020. So from the date of filing, if anybody has manufactured it, if anybody has sold it, then you have all the rights over that selling, that manufacturing. So you will You will ask for royalty for their earning. The person who were manufacturing it, the person who were selling it, you will ask for the royalty, what the benefit they have received. They will ask for royalty. They will pay you by some mutual agreement. Otherwise, they have to face legal consequences. Okay. Now, patent is granted. You have all the rights. You can stop those manufacturers and sellers, and you can start your own business. You will be having monopoly in the market. Next is, what are the different points to remember for different types of intellectual property rights? So first, protect your intellectual property rights so that it should not be available in the nature, then it only publish it. First protect it, then only publish it. If you publish it first, then it will be available in the nature, uniqueness will be gone. Okay, so there will be no uniqueness, your application will not be protected. Okay, so first protect it, then publish it. Rights will be territorial. Okay, there is some exception. Registration is done by sovereign authority. Here in India, it is Government of India. It is for limited period of time. Okay, 20 years for patent, 10 years for design. No automatic relief. If somebody is encroaching, if somebody is using your rights, if somebody is infringing your rights, then you can file legal suit. Okay, it is your duty. It is not the duty of our office. Renewal fees has to be paid for certain types of IPRs. Like for patent, it is 20 years. So after patent is granted, you have to renew your application each and every year. If you don't renew it, it will be expired. You will not get 20 years. Okay, it will be expired. So exception is copyright and trade secret. Okay, and appointment of patent agent and trademark agent is not compulsory. You can file your application on your own. If you know the drafting, how to file your application, then you can file your application on your own. Otherwise, you can hire some agent, but they will charge you some fees. Okay. This is our website www.ipindia.gov.in. Okay, here you can find many details like patents, design, trademarks. So under different head, you can find different details. Okay, this is comprehensive filing. Public search, if you have already applied your application, then you can search your application here. Journals publishes every Friday. So in journals, you can see all the application which has been filed this week, which has been granted or registered this week. So suppose today is Friday, when you check your when you check for journals today or tomorrow, you will find all the application which has been filed or granted this week. Okay, acts and rules you can access here. If you are having any, if you think that you have to go some training, you have to undergo some training, then you can refer this RGNIIPM tab. Here you will find details of training programs which are being offered by patent office or design office or trademark office. So you can find this application, you can register it here. Okay, what are career opportunities? So you can apply for government job like examiner patents and design, trademark and GI, copyright. So for examiner patents and design, you need BTech degree or science degree. MSc science is needed. Okay, MSc in science background is needed. So these are others, means other than government job, patent agent, trademark agent. For patent agent, trademark agent, you need science degree, and after that you have to qualify agent examination, and then you have to register it for agent, and then you can practice. These are different act. These are different IPRs, their act and their terms. I have provided this slide also in our IPR information booklet in the feedback link. Okay, please go through that feedback link. This data is from 2019. In 2019, in China, around 1.4 million applications for patent filed. So 14 lakh application for patent filed in China in 2019. In USA, around 6 lakh application for patent filed. In India, only you can see only 53,000 application for patent filed in India in 2019. In that also, if you see, this red one is showing resident, orange is showing non-resident. So in China, out of 14 lakh application in 2019, 13 lakh patent application were filed by the Chinese citizens in China, and around 1 lakh application for patent filed by the non-Chinese citizens in China, non-Chinese citizens and companies. Similar scenario was there in Japan and Korea. Koreans and Japanese were filing more application in their countries. India, you can see reverse scenario. Indians are filing less application as compared to the foreign filing. Okay, so this is the reason government has launched the mission, because India's filing is very less. Though our population is very high, we are filing less application for patent. Also, the foreigners are filing more application as compared to the Indians. So these are the reason government has launched this mission to create awareness. If you see a single product, you can find different types of IPRs. So first, the logo for this uh, laptop is a trademark, registered trademark. If you see the body of the design of this laptop, it will be a design. If you see LED display, which is kind of technology which has been patented, so it will be patent. Next is the layout of the semiconductor. Inside this laptop, there is some semiconductor. That semiconductor has got some layout. It can be protected under SICMD design. Next is the booklet, the user manual you get with this laptop will be a literary work which can be registered under copyright. So if you're, this was actually basics of all kind of intellectual property rights for creating awareness. If you have any doubts, you can ask me now. Otherwise, in future, if you are having any doubt, if you need some training in future, then you can contact this address. You can also call us. You can email us. You can visit our website. Okay. Also, you can follow us on some social media handle. If you search for RGNIIPM Nagpur on Twitter or Facebook, you can find us. Okay. And there we will update all the training details. Okay. Registration for training we will be updating in this social media handles. Okay. If you are having any question, you can ask me. Thank you very much. You can ask me. You can unmute yourself. You can ask me.
Participants, if you have any doubts, you can ask sir directly. Participants, sir, participants are asking to share the contact details once again, sir.
Contact details. Okay, just a minute,
Yes,
sir.
sir. Lastly, thank you, sir.
Please take a screenshot. I'm sharing. Okay. Just a minute. Huh? Can you see it?
Yes, sir. Yes. Participants, you can take screenshot of it.
The website is very important. In website, you will find each and every details. You can also find contact details also. So please please note this website www.ipindia.gov.in. IP means intellectual property.
Sir, I think there is a question in the chat box, sir. What is the significance
Yes, sir.
of copyright? Is it equivalent to patent? How the copyright,
Sorry.
how the copyright and the patent are equivalent? How it is equivalent? Whether it is equivalent?
Copyright and patent are equivalent in terms of their rights, I would say. Okay, but the matter where the matter what you register under copyright is different, and matter you register under patent is different. For patent, you register your invention, which was not existing in the nature, some creation which was not existing in the nature. You are registering it under patent. Under copyright, you are protecting your literary work, your artistic works. Okay, you are protecting under copyright. So in terms of rights, it will be common, but the matter we are protecting will be different. Okay, so this way they will be equivalent. Any other question?
Thank you, Sridevi. Yes, I think your question is answered. Any other questions?
You can find the feedback link in the chat box. The sir will also share with you.
Okay. So once the session is over, we will share the feedback link in the chat box and all.
Any other questions?
Okay. Sir, I think there is no question, sir.
Is there any specific for women applicants? Yes, women applicants, there is the only expedited examination you can apply for in patents. Okay. Recorded version, actually we have not recorded this session, so you will not get this recording. Okay. Any other?
So actually, this session is available in. It has been telecasted in live right now. So once the session is over, you could find the recorded version in our YouTube page. So it's Panimalar Engineering College, CSE department.
Sir, is it necessary to wrote the abstract in 30 pages?
Sorry, I didn't get your question.
You're not clear.
Sir, sir, we
Your
want
voice
to
is not.
write our project in 30 pages, sir. Hello.
No, you're not clear. Your project?
Voice is not clear. It's breaking. You can write it in chat box. How many pages we want to explain our project? You can take any number of pages, but for 30 pages it will be free. More than 30 pages, you will have to pay some charges for extra pages. Okay. So within 30 pages you can explain. Okay. Any other?
So any queries, participants?
Government job, if you are looking, then you have to check our IP India website. Okay, for patents and design, if you are looking. For patent agent also, in our website you can find it. Patent agent, trademark agent examination. This year it will be in May, I think. May 2023. The examination will be going to happen. You can apply for
Any
that.
queries, participants?
Yes, if your project contains below 30 pages, it is again applicable. You can apply your application for 2 pages also, 3 pages also, 30 pages also, 100 pages also. Okay. But better you have to means you have to describe your invention fully and completely so that third person can understand your invention, how to manufacture it. Okay. Yes. Any other?
No, sir.
You.
Any other queries? I think, sir, good afternoon, sir.
Good afternoon, sir.
Very excellent session, sir. I think all our students and the participants are enjoyed with and very happy with this session because our PG students also having that this paper, intellectual property right and research methodology paper. And they are also participate there and our staff members and all our college students. More than 300 students have participated today. First of all, I thank to our management, Dr. P. Chinnadurai, correspondent and secretary, and directors Sakti Kumar sir and Saranya Sakti Kumar sir, Satyamar Madam, and our Principal, Dr. K. Mani, and our CSE Department HOD, Dr. L. Jabashila Madam, and all our staff members to support this program successfully to complete it. And once again, I thank to Hemant Chandrasekhar sir, speaker of the today, Chandrakar. Excellent session today, sir. We are very happy and thankful to you, sir.
Thank you, sir.
Thank all the participants also to attend this program.
Thank
Thank
you all
you,
the
sir.
participants for listening patiently. Thank you.
Thank you, sir.
Fill the feedback form. Yes. Thank you, sir.
Yes, thank you, sir.